There's often a delay between the execution of a contract to sell real property and the close of the transaction with the recording of a deed. What happens if, during that window, the seller grants an interest in the property to a third party? In Waldorff Insurance and Bonding versus Eglin National Bank, we explore the significance of notice in determining whether the original buyer or the third party has the superior property interest. In 1972, Choctaw Partnership took out a mortgage on various properties that it was developing into condominiums. In April of 1973, Choctaw sold one of its new condominiums, Unit 111, to Waldorff Insurance and Bonding for approximately $23,500. Choctaw and Waldorff executed a written purchase agreement, and Waldorff paid a deposit of $1,000. Waldorff then began occupying the unit, moving in furniture, and paying the associated condominium fees. In 1974, Choctaw owed Waldorff $35,000 in insurance premiums, and the parties reached an agreement that in exchange for cancellation of that debt, Choctaw would consider the outstanding purchase price of Unit 111 paid in full. Choctaw executed a quitclaim deed in Waldorff's favor, which was recorded in March of 1975. In October of 1973 and June of 1974, after Waldorff began occupying Unit 111, but before the quitclaim deed was recorded, Choctaw executed 2 additional mortgages, both secured by Choctaw's condominium developments, including Unit 111. When Eglin National Bank later filed a foreclosure action in relation to all 3 of Choctaw's mortgages, Waldorff argued that Waldorff's interest in Unit 111 was superior to the bank's liens from the 1973 and 1974 mortgages. The bank countered that Waldorff's interest wasn't superior because the quitclaim deed on the property wasn't recorded until 1975. The bank also argued that because several other units were occupied by invitees of Choctaw that had no legal interest in their respective units, Waldorff's occupancy alone didn't provide the bank with constructive notice of Waldorff's interest in the property. The trial court held that the bank's liens on Unit 111 were superior to Waldorff's interest. Waldorff appealed to the Florida District Court of Appeal.